You are listening to the Advocates of Aging podcast. This podcast is produced by the ABA Commission on Law and Aging. Listen to hear interviews and stories on topics related to law and aging, including best practice tips for professionals and career advice. Age is not just a number, it is an opportunity for growth and fulfillment. These episodes will explore the hurdles people face when aging, as well as opportunities for improving advocacy and strengthening the legal rights of others.
Hi, I'm Jessica Brock, here along with Erica Costello. We're with the American Bar Association's Commission on Law and Aging. You are listening to our Advocates of Aging podcast. In celebration of Disability Awareness Month, we are dedicating this episode to disability rights. Today, our guest is Steven Schwartz. Steven Schwartz serves as special counsel at the Center for Public Representation. After founding the center in 1976, and then serving as its executive director for 38 years and litigation director for 13. After graduating from Harvard Law School in 1971, he represented thousands of people with disabilities over the past 50 years. He has testified before Congress on numerous occasions, successfully resolved a number of damage cases for institutionalized individuals with disabilities, and litigated dozens of class action cases that challenge the unnecessary segregation of people with disabilities in psychiatric hospitals, developmental disability institutions, nursing facilities, and juvenile justice settings. Steven has provided training and technical assistance to disability rights programs in more than 40 states, authored a number of law review articles, and served on the faculty of the Harvard and Western New England law schools. A complete copy of Steven's bio will be provided in the notes on our website. Welcome, Steven. We are excited to chat with you today, and we thank you for taking the time to be with us and share your work in the disability rights field.
Thanks, Jessica. Happy to be here.
So tell us about yourself and your career. What prompted you to enter the legal profession, to work on disability rights, and then to found the Center for Public Representation?
Well, I grew up during a time of civil rights struggle. In the late 50s and early 60s, I was really inspired by the courage of many Black and white students who were walking in Mississippi and taking buses around the Deep South. And I had an opportunity actually to work at the Department of Justice while I was in college in the late 60s. And I was able to work with the head of the Civil Rights Division, and I spent several weeks in Montgomery, Alabama, working on a school desegregation case. So that sealed it, although I kind of had been on that trajectory a little before that. My mother used to say when I was a little kid that I used to argue very well. So that was also a bit of a career pathway. But after going to college and spending time in Alabama, I was determined to be an attorney. So I was able to get into law school at Harvard. And while at Harvard, there was very, very few opportunities to do public interest law. They didn't have clinics anywhere near what is the case today. But they did have one course that was taught by a civil rights professor together with a psychiatrist on mental health law. So I took that. Seemed like the closest to public interest, way far from tax and contracts and wills and estates. And that course was really inspiring for me to think about civil rights outside of the racial justice context, but in a disability justice context. So I began to work actually at a mental hospital and at a prison, for a forensic prison, and spent time with inmates who had been charged with crimes, who had disabilities, and I started courses down there to teach them about advocating for their own rights. And that was a natural lead-in to working after law school in the disability justice area. But also, like many, many people who are working on disability rights, I had a personal story. I had a family member who I was helping protect and try to avoid punitive and forced treatment. And I think that personal story inspired me, in a different way from the social justice issues. So they came together um, shortly after law school and traveling to Asia. I um, took a job in Western Massachusetts, mostly initially working with migrant farm workers. And one of the farm workers that I was assisting was terminated because he allegedly had a disability. It turns out there was a pattern in practice of terminating all farm workers after a certain short period of time, allegedly because they had disabilities. So I actually went back to Harvard, recruited the psychiatrist who had taught me, asked if he would be my expert, and brought my first class action case after about 4 months out of law school. And that was the beginning, I think, of a pathway for me. While doing that work, a colleague who had represented one individual at a local institution for people with intellectual disabilities asked me if I would come and take over that case because he was leaving the area. It turns out that that person, a woman, was told that she wasn't allowed to register to vote in the town where the institution was, because anyone in the institution, they told her, was automatically under guardianship. Even though under Massachusetts law, if you were formally pursuant to a judicial order placed under guardianship, you did lose your right to vote. But the superintendent of this institution took the position that everyone in the institution, regardless of any orders, was automatically under his custody and control, so they couldn't vote. So brazen as I was at that time, unhindered by any sense of constraints, reality, or judicial restraint, I decided to bring a lawsuit on her behalf against the town. It was immediately transferred to the Supreme Court in Massachusetts, and we were able to obtain one of the first right to vote decisions. This was in 1975 on behalf of people with intellectual disabilities. By then, I was really pretty sold on this as my pathway, but the last part of this was the same person who had introduced me to this woman at what was then the Belchertown State School asked me if I would assist a client at the Northampton State Hospital, a neighboring institution, but a psychiatric facility. So I went to the facility to go see this individual, and I walked through the institution. It was one of those huge buildings, housed 2,000 people, had 4 floors and a tunnel underneath, and people were all locked into wards. And as I walked through and felt and smelled the pain, it was really emotionally quite traumatizing in some ways, but also inspiring. So when I came out of the facility, maybe an hour later, I just sat down on the stairs and I started to cry. I was so emotionally moved by what had happened and what thousands of people were experiencing, that in some way that was unexplainable, almost a little, I don't know, magical. I just had an inspiration that said I would not leave the facility until everyone else left. And 16 years later, that was the case. The facility closed. We brought a class action lawsuit on behalf of all the residents at the state facility. It was filed in 1976. We did one of the first cases that engaged the Department of Justice in this work, their Civil Rights Division. The case eventually settled with a new governor, and 16 years later, the institution closed after everyone was provided a community home. So, but by then there was no turning back, and there has been no turning back for the better part of 5 decades.
That's incredible. I mean, what a shining example of seeing a need and filling it. And I can't imagine the chutzpah it takes to bring two class actions, basically right out of law school. That's incredible. Um, so tell us more about the Center for Public Representation, the work it does, and how the center decides which case or systemic initiatives to undertake.
Well, while I was working at the Northampton State Hospital after that first experience, I, I started representing people in civil commitment hearings, and one clear reality was that the number of people who were being what they call petitioned under state law was, 10, 15, 20 people every week. There was by that time 1,000 people still in the institution, and just me. So it became obvious within days that my ability to be able to impact the institution, the people, and, was significant, but it was deeply limited by resources. So shortly after I filed this lawsuit, I was able to secure a grant from the federal government, what is now SAMHSA, was then the National Institute of Mental Health, to train paralegals, because I decided, if I could have 10 people instead of one, we could have 10 times the impact. It wasn't quite that multiplier, but because I had to train and supervise and oversee and take care of and mother, a lot of people. But because the state hospital was in a, very educationally rich area in Western Massachusetts. There are 5 colleges, Amherst and Mount Holyoke and University of Massachusetts. We had a large pool of students, thousands of students. So I received this grant to train students and make them like certified paralegals. Then I was able to get all the paralegals on the wards of the institution. In the very first, one of the early advocacy efforts was on behalf of someone who was improperly restrained, and I threatened to bring a lawsuit, and the state decided they wanted to settle. So rather than getting damages or something else, the settlement that I asked for was to stop restraint of people in most situations and to give me the keys to the wards. And so I didn't have to ask anyone to be able to go onto the wards, and I could go there late at night. We then created an office on the grounds of the institution, and I lived there for a while so that I could be there 24 hours a day like people who were locked in. And with that extra resource of 8 or 10 students at the time, we were able to have a major impact. We were representing hundreds of people at any given time. But at some point, the grant ended. And when that happened, I realized it was time to form an independent organization. So we incorporated the Center for Public Representation. Prior to that, we had been a branch of the University of Massachusetts in legal services. But now we were an independent organization doing really the same work. We didn't have the grant anymore, but we now had a reputation throughout the country of promoting systemic change in large psychiatric and developmental disability institutions. But as we started doing more and more and became a designated protection and advocacy agency in the early 80s, it became clear that the original dilemma that I was in when we first started, which was there were many more people with many more problems than we could ever address at any given time, either I individually or I with 10 paralegals. It became obvious that we needed to have some rational and intentional process for deciding what we would do. Because with keys to the ward, um, the positive, of course, was that I had access whenever I wanted to everyone. But there was a downside, there was a cost. And the cost was that whenever I left the wards, which I did all day long, each of the doors had a glass window. And the glass window was included barbed wire and other terrible things. But I had, because I had the keys, I had to lock the door as I left. And there would be people, colleagues, clients who would have their face pressed against the window because they wanted to leave as well. And I had the sort of ominous responsibility to have to lock the door. And that responsibility was really painful personally. And it forced me to ask a lot of deep questions about why I was on one side of the door and they were on the other. What was it really about that caused institutionalization? And allegedly, of course, it was supposed to be about the difference in someone's mental state, but it was deeper than that. It was about race. It was about poverty. It was about family, about lack of community support. It was about privilege, being a white male lawyer, who had a Harvard law degree. But it was also, I think, about a certain coincidence of power. And I really spent a lot of time investigating that, and led me to realize that we needed to have a way to be proactive, not just reactive, in our legal work. Therefore, we had to identify what were the ostensible reasons that people were locked in or restrained or drugged, and also what were the deeper reasons, and how we would want to develop systemic strategies and initiatives to address both. So we developed a process that was, not dissimilar to what other public interest organizations do, often on an individual basis, but it was called our systemic planning process. We brought people from around the country together, not just lawyers but people with disabilities, our clients, professionals, advocates, family members, and we sat around for a day or two and kind of debated what should be the next 5 things that were the most important to do. And so we branched out, for instance, from public institutions to private facilities because they were so invisible and they were also the place of privilege. We went to nursing facilities and juvenile justice facilities. We did work that was not only about securing equitable relief, injunctive relief, changing systems, but decided that there was an opportunity to bring damage actions that would recover money damages for people with disabilities who were hurt or sometimes killed in institutions. And we had 2 goals. For instance, this is a good example of how we would try to be proactive. We thought that in one of our priority setting processes, it was brought up that the perception of most citizens about people with disabilities is that their lives were diminished by their disability, particularly if they had a mental illness or a serious physical disability, and that therefore being hurt didn't hurt as much, and that pain wasn't worth as much. In fact, I brought a damage case on behalf of a man who'd been institutionalized in 2 different psychiatric facilities for a total of 22 years. And the first reaction by the lawyer on the other side was, he's been in a hospital for 20 years. He's never worked. He doesn't have any economic damages. He hasn't paid any out-of-pocket costs because the state is paying his care in a public facility. So how much did it hurt that he choked and died? And I said the same amount as you would feel if you choked and died. And so what we were trying to demonstrate in that case was that the value of a pain and suffering for a person with a disability, even an extensive, severe disability, was equally valuable to that person. So our goal was to see if we could get damage awards or settlements or jury verdicts that really pushed the upper limit of what had happened in the past. Um, Not so much just to make money, but rather, although the money went to the individuals, the clients, but mostly to be able to use jury awards in increased value as a system change strategy. So we've done that every 3 or 4 years for 50 years. And each couple of years, we do another process. We pick another round of cases, and then we have a very deliberate, managed, intentional program to translate those priorities into new cases.
Thank you so much for talking about that and telling us about your, ways of trying to promote the systemic change through litigation strategy. What are the benefits and costs and risks of promoting systemic change through these types of litigation strategies?
Well, the primary benefit is that it's not as we know, courts are not a democratic system. And for people who are devalued, disempowered, um, uh, considered low on our uh, social valuation scale, um, they are not going to be able to convince their local mayor or their elected representatives that their lives matter, or they will have a much more difficult time. And we see that today in the most extreme way, where money and privilege is the access to power and authority and wealth. And so courts have been for decades for Black people, brown people, women, and people with disabilities, the protector of their fundamental dignity and citizenship. So the benefit is that we go to a place where, at least allegedly, all people are equal. And their rights are viewed through a prism that does not distinguish by race and color and citizenship and disability. Of course, that's not really true because judges are not, impervious to those same prejudice and conditions. But it's a little more true than having to win, the popular vote. And this was especially true in, 50 years ago when there were virtually no disability rights statutes on a federal or a state level. The limitation are two. One is the limitation inherent in courts. They can't run systems. They can't eliminate state hospitals. They can't make your community welcome you. And the second benefit is that second risk is that class action cases or any kind of litigation has a natural ending. And when that ending happens, the case is over, the matter is dismissed, even if most of the goals of the litigation have been achieved. There is a deeper question of whether that change is embedded in the community, whether without the oversight of a federal judge, whether the change that has been adopted pursuant to a court order will survive. In the case that in the first class action case we did on behalf of a wonderful Black man who had been institutionalized for 15 years, David Brewster. He was from Northampton. He was brought to the state hospital when he was 16 years old, allegedly because he put his hand on someone on a bus, and he was then deemed incompetent, and he was sent to the hospital for a competency evaluation. And when I met him 9 years later, he had never left the cubicle in which he was living. And so it took a mammoth effort just on a personal level to try to transform his experience to be willing to leave the facility. And so that's another, limitation of litigation, is that we have to be able to um, embed within people with disabilities, within our community, the confidence, the determination that they too can be full participants in the community after decades of being devalued.
Yeah.
When at one point in the implementation of the case, the state legislature decided to cut off funding or not increase the funding as was required by the consent decree. And there was a bridge in the city of Northampton that on top over one of the main streets. And the next morning after the legislature made this decision, I went by the bridge and there was graffiti on the bridge that said, "We all have a right to live in the community." So I have no idea who put that graffiti up, but there was something about the case that I knew had become part of the community, that had been embedded and would survive after the judge went away. But that's often not the case.
Right. And I think we should talk a little bit about that. You bring up so many different cases you've been involved with that have had such meaningful impact on the lives of the people you represented, and the lives of individuals with disability. After a case settles and you've received a court order, what happens next? How do you take some of these, proactive steps to help implement these systemic changes in our community?
Well, most of the cases that we bring have a half-life of about 5 years, but a duration of 15 or 20. So when we bring the case, because we know that what we're trying to do is fundamentally disrupt how a program or an institution or a community system is operated, and reconstruct it in a way that empowers people with disabilities and values their lives and contributions. That's a big change, because it's a change not just in funding and not just in location, not just in staffing. It's a change in values. So that is going to take a long time. The two reminders I used to have was I would always go to these institutions, like the Northampton State Hospital. It was built in 1872. I brought this case in 1976, 100 years later. So I used to say to myself, it took 100 years for them to do what they have done. If I can undo it in 20, that's 5 times faster than what had happened. So 20 years to undo the pain and suffering of a century was actually quite fast and quite modest. And so the other anecdote to say is, after one of these cases that I brought, class action cases, someone from the local newspaper asked, they said, something like, "How long do you think it's going to take before the goals of this court order are achieved?" And I said, well, it somewhat depends on what you think of the goals. If the goal is to create a number of community mental health programs and have a lot of people leave a hospital, it says in the court order that it's supposed to happen in 5 years. I think if it happened in 10 years, it would be great. But if you think that the goal is to actually allow people to have a full life, if for people, with disabilities to think of marriage and think of work and think of an independent contribution and voting in our community, that's going to take a lot longer, And I said to this reporter, I need to remember that even when that community program is in place, and even when they're voting and have a job and so on, that doesn't eliminate their disability. right? And so their disability may be lifelong, it may be generational. And so there is, even a longer trajectory to being free of the stigma and the pain, and some difficulties, that they might experience. And even then, there's still poverty. So all of the work we do is with a recognition that beginning a case is at least a 2-decade undertaking.
Well, that's quite the undertaking to understate the issue. As we said at the beginning, March is Disability Awareness Month, and one landmark disability rights decision is the 1999 Supreme Court Olmstead decision. Could you briefly explain what Olmstead was about and what the decision means to disabled people?
Two amazingly courageous women who were institutionalized in a public psychiatric facility in Atlanta, Georgia, stood up to be counted and to have their names and their lives as a symbol to hundreds of thousands of other people with disabilities who were institutionalized. At that time, there were 500,000 people with intellectual disabilities institutionalized in facilities, and many more than that institutionalized in psychiatric facilities. So Olmstead was really two things. It was a personal story of these two women who struggled to come home to their communities, to their families, to their churches, and to their loved ones. But it was also a story of the tragedy of institutionalization across the spectrum, of different types of disabilities. I brought a case along with others in New Mexico, and one of the on behalf of people with intellectual disabilities, and one of the institutions, which was in southern New Mexico, I went to visit to be with clients, and I noticed that there was a water tower on the institution grounds, and the water tower had a swastika on it. And I asked, what is that about? And they said, oh, that is its prior incarnation of this institution. And I looked up the history. It turns out that facility had initially been a fort where they imprisoned indigenous people. And after that, it became allegedly a hospital where people with epilepsy were institutionalized against their will. And then in World War II, it became a Nazi internment camp. And after that, it became a state institution for people with intellectual disabilities. So this one property had been a place where people were locked up for different reasons, different disabilities, for over a century. And so that became obviously an inspiration for us to make sure that that institution was forever closed and demolished so it would never become another place. And the Olmstead decision was about that history. It was after that institution had become one for people with intellectual disabilities, but Olmstead decision helped put that final ending so that we could close and demolish that institution forever, and it didn't become just another place for another devalued population. So Olmstead, over the last 25 years, has become both that powerful, inspiring story of two women, but also a way of really having a historical reckoning with what we as a society, and not just America, Europe and Asia as well, have done to lock up and try to erase the lives of people with disabilities. Because institutions, more than anything else, are a way of making people invisible. and Lois Curtis and others who were the plaintiffs, the two women in Georgia, were about, their first and most powerful statement was, "You will not make me invisible." And so in the last 25 years, I think we have used the case in a technical way, in a sort of legal way, to make arguments and to close institutions. Well, first to help people like Lois and others move out of facilities and come back home, but also to force this historical reckoning to what we have done as a society and what we need to undo and ask forgiveness for.
Thank you for that. And yeah, what a powerful story. Are there other tools or vehicles besides the Americans with Disabilities Act and Olmstead that support people remaining in or returning to their communities?
Yes, there are a lot. There are the basic constitutional rights that we think of that was important in that very first voting case that I did for a woman at the Belchertown State School, because it was we were asserting the constitutional right to vote. But in that constitutional provision, and in all constitutional provisions, is that embedded notion of equality. And so using the Constitution or other foundational legal principles to demand equal access, equal recognition, equal rights and privileges is, to me, a starting point. Then there are various statutes like the ADA, its predecessor, Section 504 of the Rehabilitation Act, but many other statutes that are designed to promote integration and equality in school, IDEA, at work, the Workforce Opportunity Act, and a variety of other federal statutes that are about subparts of people's lives, where they work, where they go to school, how they live, how they vote. The Voting Rights Act and the Voting Rights Amendments are subparts, or they're independent statutes that deal with subparts of our lives in our community. And then, of course, there's the resources that are necessary to help reestablish people where they live with their families. A lot of what we think of in our work now it's all about bringing people home. Everyone deserves that home. Everyone started in some form of home. Then they were displaced, whether they were displaced because of their immigrant status, displaced because of their disability, and they were removed from their home, from their churches, from their families. But a lot of our work now is designed to sort of serve that larger goal of bringing people home. And so there also are the funding mechanisms like Medicaid and education funds that allow people to come back home. Home and community-based services in the Medicaid Act for children, a portion of the Medicaid Act that's designed to provide medically necessary supports for kids so that kids who are born with very significant disabilities don't have to go to institutions anymore, because there are resources under Medicaid to be able to keep them home. But like everything else, rights on paper are not the same as rights in practice. And so disability lawyers need to, be vigilant in enforcing those different statutes, state statutes, federal, and funding programs.
Steven, when you look at the disability rights field today, what do you see as the most pertinent issues going on right now?
Well, there has been a sea change in disability justice and disability rights over the 50 years that I've been practicing. It is now a given, but it was never, for a long time ago, it was not the case that um, disability rights are ultimately the responsibility and the characteristics of people with disabilities, not just their lawyers. And so having people with disabilities determine what the priorities are, be in leadership roles in the organizations that are promoting the systemic change, be the decision makers about what matters to the community. That's something that is a radical transformation of 50 years ago. It was unheard of when I started practicing at the Northampton State Hospital to think that one of the residents of the hospital would actually be in charge of a program or a service or be able to make a decision. I mean, they weren't even allowed to vote, in a federal for the president, let alone determine what supports they would need or want. So, but that goal of empowering people with disabilities to take control of the services and the systems and the structures that impact their lives, is not fully accomplished for sure. I think it is now an accepted characteristic of all our work, but it is not fully achieved. So one of the things that I think is most important today in the disability rights field is to fully empower people with the disability community and have their voices, equally heard. They were not, there weren't many disability platforms or disability talking points in the last presidential election on either side. There were not, you know, in the way that certain communities had galvanized in the electoral process and had caught the attention of the elected officials so that they would have a platform or a position on that issue. We still have a long way to go. In Massachusetts, the person who is in charge of making decisions about whether individuals who are involved in any criminal justice activities are civilly committed or because of competency or things like that are the district attorneys. So district attorneys have a lot of authority about how and when people with disabilities are going to be incarcerated. So I decided that in one of our cases, an election case, that what we ought to do is there was an election coming up for the district attorney in our county. So I decided to have a candidates night at the state hospital. And I invited all the candidates for the district attorney and said, you have a huge amount of power over the lives of people in this institution. And they need to know what your position is on civil commitment. The candidates were stunned. Most of them didn't come, but one of them or two of them did come to the candidates night. And that type of accountability by public officials to the disability community is another, goal that we have a long way to go. And lastly, I think that the rights that we have on paper, including the ADA and 504, are far from fully achieved. And so we have, I can say to my kids, you could spend the rest of your lives, the next generation, just enforcing the rights that are on paper. And you would, if you could, you would dramatically reform and transform our communities.
How very right you are. And do you have any words of wisdom for attorneys or maybe law students who are wanting to go into the disability field or maybe considering a career change in their field at all?
Well, I think that there are many disabled lawyers or law students coming out of law school who I think are uniquely positioned to do work because they have the personal experience of what that means. But you don't need to be disabled to be a good disability attorney, although it certainly gives you an insight that others might not have. But in the absence of that, I think it's worth constructing your own situation like the one that I had when I had the keys to the hospital door. And I would see people on both sides. There would be me on one side and the person with, who was in this mental hospital on the other. And it forced the question, what's the difference? Why? And I think that question is one we all should be asking. And for disability lawyers, whether they have a disability or not, I think the question of what does it mean and why is it so that our communities have so erased or made invisible through institutions or through lack of employment or through lack of access, people with disabilities. When the very first curb cut case was brought, the people who benefited from the case in the beginning when the city decided to chop away at that curb and allow access were moms with strollers. It wasn't just people in wheelchairs. It was all of us. And, whether we think about universal design or think about that it's quite possible to construct a world in which access is not a problem, where we all have access and we all benefit from the access. Similarly, while it isn't the case that we can eliminate the underlying conditions of disability, injuries or heart attacks or such like that, we can eliminate the secondary negative consequences, the devaluation, the lack of employment, the prejudice, the stereotypes, the stigma, the curbs that exist in all of our communities that make it impossible not just for people with disabilities in a wheelchair to get from the sidewalk to the street, but for all of us to get from the sidewalk to the street. So I think being able to look at the world, both architecturally, environmentally, socially, emotionally, and spiritually, to look at all the ways in which we have created curbs that make it impossible for people with disabilities to have the same trajectory in life that we do, that others without disabilities. And lastly, to remember that, when I was teaching, I would ask all of my students at one point to close their eyes, see if they could imagine themselves 80 years from now. What was the disabling condition that they had? Because they all were going to have a disabling condition. Because that's the nature of, disability isn't reserved for some people. It happens to all of us in some way or another. And so the very idea of separation to something that is going to be inevitable is something that I think I've tried to talk to students and friends about. If we recognize it's already happening, we are already there, and we can create a world that doesn't have curbs for all of us. That's what I would say.
Well, thank you so much today for your time and talking to us in honor of Disability Awareness Month. And if you're interested in further information on this and other topics, please check out our podcast notes on our website. You can also listen to this and other episodes by visiting the ABA Commission on Law and Aging's YouTube channel. Remember to like and subscribe to be sure to get any updates. We look forward to having you join us for our next episode. In the meantime, keep on advocating for the legal rights of all. Thank you.